Hi, my name is Matthew Jeffery, and I'm an immigration lawyer based in Toronto, Canada. Today I'm going to be talking about the time limits involved in residency appeals. If you are a permanent resident of Canada, the Department of Immigration, Refugees and Citizenship Canada, or IRCC, has the authority to revoke your permanent residence status if you do not meet the residency obligation of remaining in the country for at least 2 years out of any 5-year period. IRCC will review whether you are meeting the residency requirement when you apply to renew your 5-year permanent resident card or when you apply for a travel document to return to Canada from abroad. If during one of these applications the immigration authorities find that you are not meeting the residency requirement and none of the exceptions to the residency requirement apply, then you can lose your status as a permanent resident pending any appeal. If you receive a negative residency decision, you are allowed to appeal to the decision of the IRCC to the Immigration Appeal Division for a hearing to get your permanent resident status back. An appeal is initiated by filing a Notice of Appeal to the Immigration Appeal Division, or IAD, registry in the province or territory where you last lived in Canada. The Notice of Appeal should also be accompanied by the written reasons of IRCC explaining why you did not meet the residency requirement and have lost your PR. You must file the Notice of Appeal in your region's IAD registry office not more than 60 days after receiving the written decision from IRCC. This appeal limit is longer than the usual 30 days for other kinds of appeals because those who have lost their permanent resident status will often be outside of Canada and will be making an appeal from outside of Canada. When filing your Notice of Appeal forms, you may indicate that the IAD that you would like to return to Canada for the appeal hearing. You will need to get a travel document since your permanent resident card will be expired and you cannot return to the country through any kind of commercial flight. The Appeal Division will decide if you need to be physically present during the appeal hearing or not. You can also obtain a travel document to return to Canada if you have been in Canada at least once in the past year. Sometimes the immigration authorities issue this type of travel document at the time they refuse a regular travel document application, so it is important not to confuse the two documents. If you are able to obtain a travel document to return to Canada, once in the country you can apply for a temporary 1-year permanent resident card so that you can travel during the appeal process. The IAD will schedule a hearing in every case. It normally takes about 1 year to get a hearing, but may be faster in some cases. The date of your appeal hearing will be scheduled in assignment court, or the IAD can communicate a date directly with your lawyer. I'm Matthew Jeffery. Thanks for watching.